All rise. The Superior Court of Fulton County, Atlanta Judicial Circuit is now in session. The Honorable Judge Charles M. Eaton Jr. is presiding. Court will not come to order.
Please be seated. Good morning, everyone.
Good morning, Judge.
All right, we'll do, let's do announcements for this final plea and trial calendar call. Position 1, 2, 3, 4, right? The Satterwhites and Evans. What are the announcements on the Satterwhites and Evans?
Well, Judge, good morning. John White on behalf of the state. I just would inquire, Your Honor, if you're going off of, it looks like you're going off of an earlier published calendar. We did receive a revised calendar, which had a different order with Bjorn Harris as being the lead.
That's trial calendar.
All right, so, okay, so I just want to make sure we weren't forgetting Bjorn Harris, I suppose.
Is he on this?
Okay.
Okay, he's on here.
All right, thank you.
Sorry, it's different than Because I literally, it's still hot from the printer.
Understood, Judge.
So, but okay, so the Satterwhites and Evans.
I'm present on Mr. Evans.
Okay,
I'm not sure that I knew he was back in custody. It appears so, but what says the state?
State is written.
okay. I know we have a pending severance on it.
I believe my co-counsel did file a severance.
And you signed on to it, correct? Is there any other outstanding motions?
No, Judge, not from the state.
Well, I guess where's Miss Williams?
I'm right here, Your
Oh,
Honor.
okay. All right, well, we're taking announcements right now. So what is going on with Mr. Satterwhite?
There has, just from talking to him, been a change of heart. I need to speak with Howard a little bit, but I think there may be.
Okay. All right. That's all I need to hear for now. Position 5, Naiza Reeves. Now we continued this, right? Yeah. All right.
And do we have a new date yet?
No, because I'm going to want you to sign it in blood
Yes, Judge.
when we have that date.
And
Although you don't need to,
I was
Mr.
just
Reed.
gonna say, Judge, for the record,
Mr. Williams needs to sign his date in blood when we come up with it. So,
okay.
but we do need to get a date, and you're going to need how much time? Because I know you have those interstate compacts.
Yes, Judge, we'll have to do interstate compact and it typically takes 30 days. I know this is one that we've kind of already had some communication on, so it may take less time, but I would, to err on a side of caution, I'd ask for the full 30 days notice so that we can make sure that all parties are properly served.
Well, what I'm going to do is I'm going to conference you and Kendrick in again and have both of you just commit, and we'll specially set it for the third time. And, we'll see. We'll see how that goes. All right. Okay. Position 6, Elmine. We reset that too. That's right. Pending discovery. Position 7, Bagnarisi.
I am present on that, Your Honor.
Okay. You need to talk to your client or okay.
Good morning, Judge. John Whitenauer for the state. It's my understanding that if we turn to position 8, Christopher Cyprian, which would be co-defendant, position 7, that defense counsel Bruce Harvey has filed a conflict for today. And then also the trial calendar dates of 12/4 and 12/11, citing the ISL trial, which begins today.
Yeah.
Based on that conflict notice, Judge, I think that this case would be properly continued.
Ms. Jones?
That is my understanding as well, Your Honor.
No, I understand. I mean, Mr. Harvey's been in here a few times and I have that conflict memorized, but all right. Did you need to talk with your client at all?
I'd just like her to stick around for a moment, but then may she be excused after that.
Yeah, yeah. So you've heard it. So we're gonna continue the case. You're excused after you're excused now, but your attorney wants to talk to you. So I'm sure you'll stick around for that. All right, position 9, Bazile.
Good morning, Your Honor. He's in custody. I'd like a chance to speak with him.
Okay. Position 10, Lewis. That's
Yes, Judge.
I'll go ahead, Mr. White now.
Thank you, Judge. Yes, Judge, Ms. Rockwell did email, the state and,
He did.
court advising that she has leave through 12/1, that'd be this Friday, and requesting that this case be continued, from the trial calendar. The state has no objection to that request for continuance, in light of the fact that it is focused, at least from this prosecutor's perspective, on some other cases on this calendar.
Mr. Clark?
So for Ms. Thomas.
Oh, never mind. Never mind. I thought they were never mind. It's actually, yeah, so you were getting to that. It's actually Thomas and Lewis, so.
Thomas is here.
Yoka Lewis is here as well.
Yeah, no, I heard you. Is Mr. King on?
Judge, he did email, he advised that he was in the cab for some trial calendars. He requested to appear by Zoom. And indeed, in that email, he also announced that his client, Ms. Thomas, would be wanting to proceed to trial.
Miss Rockwell is by Zoom. But Mr. King is not yet. All right, we'll circle back to it.
Yes, Judge, I'll be listening.
Okay, we're just waiting on Mr. King.
Yes, sir, I'll send him the link. Thank you, Judge.
All right. Possession 12, Murphy.
I'd like the chance to speak with them. I received an offer from the state recently.
Okay, position 13, Harvey.
I am present on that, Your Honor. I think, who has this for this? Okay,
You have it, Miss Willingham?
I'll get with the state. I am still missing body cams in regard to that, and I don't have an offer, but I'll get with Ms. Willingham. I'm sure we can talk about that, so just retry it for now.
All right. Position 14, Thompson. Mr. Tucker around?
88 Asia, basic for the state. I have been in contact with Mr. Tucker on another case, and I do know that he has a conflict for today. He says that his office was going to file it pre-Thanksgiving. But he did text me the conflicts. He said he had to leave for appointments, medical appointments today. I did not see the conflict letter in my case. Not sure if it's in the other case, but I do know that is, his announcement on Miss Ingram's case, at least, which makes me think it's on this one.
All right, well, we'll circle back. I mean, if
He might be able to log on to Zoom, but I know he's at appointments.
yeah, I guess
Plural.
just see if you can reach out to him, see if you can log on to Zoom. Position 15, 16, 17, 18, and 19, Royce Bell.
In custody, Your Honor.
If we could recall that, Your Honor.
All right. Position 20, Bridges.
In custody,
Well,
Your
I'm
Honor.
21 is Bridges as well.
Attorney Mr. Lewis asked if you could hold for his report, please.
Okay.
Yeah.
Position 22, Sharp. Ms. Rockwell.
I represent this shop.
Okay, sorry. All right, Mr. Kendall, what's your announcement?
Good, we have not received any discovery nor offers from the state, so. I asked if I could try.
Who's got this with the state?
Yeah,
Oh.
we would have sent everything to Ms. Rockwell, because she's the person listed on the case, but I can get it to her today.
Okay, well, he's asking to pre-try it as well, so,
Okay, that's fine.
okay. All right, when we take a break, you can. Position 23, Liz, position 23, 24, Lizka.
Mr. Liska this morning,
We'll circle back. Position 25, Lee.
Mr. Lee is present, Your Honor. We may be able to reach him.
Okay, all right. Position 26, Mills.
I am present on that, Your Honor. I have spoken to the state. We are in active negotiations. As I indicated to Mr. Mill, or the state, I've been preoccupied with a couple weeks of trial, so I haven't had a chance to sit down and go over some of those videos where the complaining witness talks to the victim advocate. I would just request, again, another reset. I know it was reset from last month, but I've had a pretty busy November, Your Honor, and this is a very, very serious case. They actually need to watch those videos.
That's correct, Your Honor. And the state has sent an offer. We're open to negotiation, so we are working towards a resolution.
All right. Let's see here.
Thank you, Judge.
All right, one more reset.
Thank you, Your Honor.
Position 27, Allison. Ms. Clark.
I don't see Mr. Allison here, Your Honor. The last time he informed the court that he was hiring Scott Fortes, and I never saw an entry on that. I don't see him here.
All right, we'll circle back on that, see if he shows up. Position 28, Pierce.
I am present on that, Your Honor. I'd like an opportunity to pre-try that with the state. We've been in negotiations.
Okay.
Yes, Your Honor, that's gonna be my case.
Position 29, Rogers.
Your Honor, I got an offer late last week. I need to convey that to him, so I just like to pre-try both his cases.
Oh, that's right. There's two cases, so that's 30 as well. Position 31, Jefferson.
Stand up for me, Dr. Reggie. Stand up.
Okay. Ms. Marsh, you have that one?
Yes, Judge.
All right.
Discovery is completed, offer has been conveyed. We're ready for trial.
Okay.
And Your Honor, I'm Attorney Foster's co-counsel, Attorney Hawkins, but she did want you to hold her report.
All right, we'll hold.
She'll be here momentarily.
Position 32, Harris.
He just arrived, Your Honor. He's here.
Okay.
Morning, Judge. This case was null prost. The state provided a proposed order, state signed and filed that because it has been re-indicted for murder under 23 SC 190-910. So the defendant would need to be arraigned on that new indictment before we can proceed to trial.
That's correct, Your Honor, and I objected in the email from the ABA about the null clause, but Your Honor did sign the null clause. I just want to put my, but he hasn't been arraigned on the new charge.
Okay. What's the new case number? 190 what? 910. Oh, here it is. So he needs to do a plea arraignment. We can do that today, I assume. Mr. White, now what's your position on the speedy on that?
Well, Judge, I think the speedy still stands, and so it would need to be tried within this term, which would end end of this month. I do have some thoughts about how we could proceed in this two-week trial calendar with this case and some other cases that appear ready. Happy to share those with the court whenever it's ready to start talking about lining trials up for each of the 2 weeks.
Well, I think, don't we have a civil trial for the second week or? Yeah.
Okay.
Anyway, I'll be happy to hear any suggestions you have on that, Mr. Whitenauer.
Can you, just like I was going to go with the indictment with him,
Sure. When we go to break, you can talk to Mr. Whitenauer about.
and say I waived the form after I go over the
Yeah. And we can talk about. On break, I'll make some calls on that civil calendar as well.
Thank you, Judge.
All right, position 33, Chuck. All right, so this is your case, Mr. Bridges.
Yes, sir.
So the attorneys filed you said the attorney filed a leave?
He, last time, June, said he was gonna file. And I did talk to him, last week, and so he told me-
Mr. Bridges?
Where's the defendant? Is he excused too? Your Honor, I'll leave that in your discretion.
Well, did you tell him that he's excused or did he just ask? See, I have in November, I have that Welch and Chuck were on Zoom. D says need an audio and video that is exculpatory. Reset to December, which we did. Bridges says he sent the video. Yeah. All right, tell them we'll reset it one more time, but send them an email and tell them that you know, unless it's filed in here, I'm not accepting it. As defendant needs to be on as well if he's listed. I mean, all of this was just based on an assumption I was going to grant it. All right. Position 34, Jeter.
Your Honor, Deion Peoples for the state. State's ready to proceed on defense counsel's motion. Haven't heard from defense counsel.
Well, why don't you reach out and see where where your son's attorney is, and we'll circle back. Well, can you reach out to Kaufman? All right, we'll circle back.
Thank you. State's ready, Your Honor.
All right. Position 35, Ramirez Herrera.
Your Honor, my attorneys have a copy of his leave of absence list that he sent to the clerk's report, and he's not here today. That's all. I wasn't able to get a hold of him all last week.
He filed one. All right. Okay. You're excused, Mr. Ramirez Herrera. We will reschedule. All right. Position 36, date Roderick Davis. I know she's filed a, I mean, all these people that, that's why, because I was going to say, just try to, I mean, this one, obviously, she didn't file it for this, but if they've got LOAs, try to keep them off the calendar, but we'll circle back to that. Position 37, Truitt.
Mr. Truitt is present, Your Honor. Since the last time we recorded a few weeks ago, we resolve the outstanding GBI reports for DNA. Spoken with Marsh, confirmed, Ms. Marsh confirmed there's not any discovery outstanding, from what I can tell, and we would just be standing on our not guilty plea.
Ms. Marsh?
Your Honor, yes, that's correct. An offer has, been conveyed. It's my understanding that Mr. Truitt, has declined that and would like to proceed.
Are you ready for trial?
I don't, it depends on which date. He's not on for the next week calendar.
Oh, he's not?
No, Judge.
Okay. Okay. All right. Is that you, Mr. Truitt? Do you need anything to talk to Mr. Truitt about?
No, Your Honor, maybe he'd be excused.
Yeah, that's what I'm getting to. So you're excused. We'll get you scheduled on a trial calendar, okay? All right. Position 38, Wagner.
I am present on that, Your Honor. The state and I are pretty close to a deal. I got a voicemail from him this morning, so I would just hold and pre-try it.
Okay. Position 39, Kirk.
I'm present, Your Honor.
But your client is not. All right, we'll circle back. Position 40, Shepard Tigner.
I am present on that, Your Honor. You may remember he didn't appear a couple weeks ago. I've reached out to the phone numbers I have and I haven't been able to get a hold of him.
That's right. We didn't notice him properly last time. Did we notice him correctly this time, Kathy? All right, we'll do a bench warrant bond forfeiture.
Judge, as to position 39 for the state, with that defendant not being present, the state will move for bench warrant bond forfeiture on that case as well.
Yeah, I mean, that's fine. I tend to hope that they show up, but obviously if they show up, we'll rescind it. But yeah, we'll do a bench warrant bond forfeiture.
Understood.
I go through it one more time, but if they do, I'm sure she will be vigorously raising her hand. All right. 41, Gresham.
Present on that.
William Gresham.
And Judge, hearing no response, they can move for bench warrant bond forfeiture.
All right. We'll do a bench warrant bond forfeiture. Position 42, Curry.
I am present on that, Your Honor. I reached out to her last week. You may recall she's in confinement basically in Indiana. She let me know she's on work release or doing work she cannot get off today. She wanted it rescheduled for Wednesday or Thursday, which obviously we cannot do. She indicates she'll be released in 43 days from the work release where she can't get off. So we would just request 30 days, Your Honor.
I'm sorry.
Oh, I'm sorry. I thought he was like, he wants a bond forfeiture. She's already in Indiana custody of the Department of Probation. I think it's community sentencing, Your Honor. We're gonna work this out. I just need to be able to get a hold of her when she can actually be more free and available.
And I did see her last week via Zoom, Your Honor.
So you're good with the reset for 30 days. Okay, we'll reset it for 30 days. Position 43, Latrice Bennett. Oh, both 43 and 44. All right, there's Miss Bennett.
I am present on that, Your Honor. We can retry it.
All right. Okay, well, that's all the announcements. Is there anything that I can address right now before I take a break?
I just want to make a correction as to condition 13. Body cam is turned over back on October 25th, as well as the offer from the state.
I don't have the offer, and I was just looking at my emails, and it was provided in a downloaded format, and I've informed the state that my computer, as well as our back drive that the county also shares with us, cannot support it. It needs to be shared with us, but I will absolutely get with the state to make sure that that is done.
Well, perhaps you can pre-try it, so.
We can, and I'll see what the offer was as well. No worries, Your Honor.
It was forwarded again this morning.
Okay, all right.
Good morning, Your Honor. Tim Lee Foster for Mr. Jefferson. He is number 16 on the trial calendar.
Which is, do you know what he is?
He's number 31.
He's number 31 on this calendar? Okay.
Yeah,
No, that's all right. There's been a little bit of confusion. You're not the only one that's been confused by it. So you've got Jefferson?
yes, Your Honor.
Okay. All right, go ahead, Miss Foster.
Your Honor, I believe that we're ready when reached, but I believe I'll speak with the state. I know that there's some issues with out-of-state witnesses, but we're ready whenever the court needs stuff.
Miss Marsh?
Yes, Judge, the same announcement that I made, we're ready.
All right, so you're ready for trial, Miss Marsh?
Yes, Judge.
All right, we'll stick around, Miss Foster, for a minute, and we'll have a better idea of how this trial calendar is going to go. What? Okay. 1 minute. Which position is that? Miguel Wagner.
That's my case, Your Honor.
What position is that?
38.
38, thank you. Okay, well, he's on Zoom and Ms. Jones requested to pre-try that. So we'll keep, anything else we can address right now? All right, I'm gonna take a break. Call me back out when everybody's ready.
Ms. Jones. I need to talk to you.
Please do not speak in open court.
Okay. Sorry.
Or you can email. I'll
All right, Mr. King, Ms. Rockwell, are you online? Hello? I see Mr. King.
Hi, Judge.
Okay, and I see Ms. Rockwell. Okay, so this is getting back to announcements for 10 and 11. So we've got Lewis and Thomas. So go. Why don't you go, Ms. Rockwell, first?
Yes, Judge, and I am dealing with Mr. Whitenauer. So I don't know if he's present, so I can make this announcement. And
He is.
just put in chat. Okay, Judge. We are in recent receipt of a long list of witnesses. I had asked Mr. Whitenauer if he could get me full names and extra details on these witnesses, like addresses, date of birth, et cetera. So we would be able to run the GCIC on these witnesses. And I understand the state is going to be helping with that information and getting that to us at as quickly as they can. And unless they're not willing to go forward with these witnesses, Judge, and I can't really say what their move is, Judge, but based on this recent receipt of this list, I'm gonna announce not ready. I don't know how Mr. King feels about that.
All right, Mr. King.
Same announcement, Your Honor.
Mr. Whitenauer.
Thank you, Judge. Yes, state did provide list of witnesses to defense counsel for both defendants as required by Georgia law. There are some witness names on there for whom the state only has their name and telephone number, but my investigator is working on obtaining that additional information, addresses, date of birth, so that we can provide that to defense counsel. Yes, those witnesses may or may not be called at trial.
Okay. Anything else from the attorneys?
Other than that, Judge, do you need, I'm technically on leave, so let me thank you for providing the platform to allow us to announce via Zoom. And I'm in also recent receipt of the trial calendar that Ms. Robinson has sent to all of us. Is that something that the court is considering calling in that particular order?
No,
I understand.
no,
Then-
it's in flux right now, other than
Okay.
the one that's currently listed as one will more than likely go as number one, but
Understand. Would the court then grant my request for a continuance based on the latest witness list and keeping in mind that the state, I know the state is working on getting us the details so that we can run GCICs on any of these potential witnesses?
Mr. Whitenauer, any objection to that?
Judge, the state has no objection to that request in light of the fact that as the prosecutor assigned to several cases on this calendar, in addition to the fact that I do have trial calendars in 2 other courtrooms for December 4th. No, I do not have an objection.
Okay. All
Thank
right,
you so
we'll-
much, Judge.
We will continue
I feel
those
like
2
I'm
items.
winning, so I'm gonna say nothing else except
Okay.
thank you, and may we be excused.
You're excused.
Your Honor, before you excuse Ms.
Thank-
Rockwell, you also have-
Wait a minute, Ms. Rockwell. Uh-oh.
36.
I'm here. I'm listening.
All right, so Mr. Bridges just brought up, you've got position 36, which is Roderick Davis.
Judge,
Oh.
may we be
Do we know if
excused?
he's,
You're excused, Mr. King.
Thanks, Judge.
and Yoka Lewis, you are excused. Judge, last
thank
time
you,
we were
Judge.
on the calendar, we had discovered that he was in jail in some godforsaken northern state. Does Mr. Bridges have any updates?
Yeah. So Mr. Bridges didn't know that is saying he's coming to the mic, but he didn't realize that Davis is unavailable.
Okay, but he does remember last time we were, the same day we moved Maceo Usher, we had done some research and found him in some northern state in some county jail with new charges. Is that still our understanding, Mr. Bridges?
No, I don't remember. I'm sorry, Renee.
Okay, all right. Well,
If you want to
let
shoot
me
me an
do this.
email, I'll shoot me an email with information. I'll look it up at that point in time. I'm putting myself a
Okay.
note right now.
Okay, and I'm gonna include Ms. Robinson, Judge. Let me just say this. We're not going to trial on our case. We are not. I just have to get him in the courtroom without a warrant. I've been given a wonderful offer and I would like to accept that offer. Last time we were there on the same day we did Maceo Usher, we finally discovered that he was in jail somewhere. So I'll include Ms. Robinson, and if maybe Mr. Bridges could run another NCIC on him, we could figure out if he's been released yet.
All right, we'll reset it.
Can you just put him on a plea calendar, Judge?
Yeah.
Thank you so much.
Okay. Is what position is Miss Clark's case? Miss Clark's? We're watching a video?
Position 32, Judge.
All right. Is there anybody else we can?
ready on Mr. Satterwhite.
I'll tell you what, before we begin with that, so Mr. Whitenair, you'd mentioned earlier you had some thoughts about the December 4th calendar. I'm always interested in.
Well, Judge, those thoughts assumed that there was, my understanding is that the trial calendar would be a 2-week trial calendar, but I'm hearing that the second week would be a civil trial.
Probably. I mean, if you, so you, what, were you trying to push the juvenile to the second week?
I was.
How long do you think that trial is going to be?
3 days. I mean, it's not too many witnesses in that one, Judge.
All right, let me get back with my staff attorney because the top of that list is only going to be, I think, a 1-day bench trial. So there still may be a way to work that, but
Judge, and if it were to go the second week, then the state would be asking that Jefferson case go on the 4th.
Okay. Let me talk to my staff attorney when I break again.
Yes,
but
Judge.
all right, so who do you want to do right now? Jimmy Satterwhite Jr., have you got the paperwork?
Yes, Judge, I do have that.
All right. Come on up, Miss Williams.
Yeah, just for clarity, do we still have to wait or can we just expect to be called in on the 4th? Or Jefferson?
Where did I leave that?
You need Mr. Satterwhite on the fact.
So that you wanted to look through your other cases, and you would let us know. Mr. Jefferson is out on bond in this person.
What? Yeah, but I need to think. Why did I tell you to? There's a reason I told you to hold on.
You said that you had to see how all the other cases fell on your calendar.
Okay.
Also, Your Honor, you haven't started calling the trial calendar yet. So that's a totally separate calendar you have. So there's two calendars for today, the final plea, which we went through, and then the trial calendar as well. I think Mr. Whitenaur might have a copy of the actual trial calendar.
So this, according to you, this is everything. But we can certainly discuss the trial calendar,
Right.
but
Little and Ingram are on the trial calendar as well, but not on the final plea. So there are a couple of cases.
wait a minute, did you hear that, Kathy? Little and Ingram are on the trial calendar, but they're not on the final plea.
All right, you do have to sign this one. I think.
Yeah, but if this is trial calendar call, we got to call them at some point, right? Okay. All right. All right, so you don't have anything other than you're ready for trial, Miss Foster?
Yes, Your Honor.
Okay, you're excused.
Thank you.
All right. No, that for Foster would be the first if it gets called, but the second week is still sort of a possibility, but all right, you're welcome. Let's do a few pleas and then we can go over the trial calendar to try to get folks moving. Yeah, we'll do that right after this one, but we were looking. We were looking.
All right. Judge, I'm ready whenever the court is.
Okay. All right, so this is 20 SC 174-533 and 19 SC 173-443. Jimmy Satterwhite Jr., who's present in the courtroom with his attorney, LaToya Williams, and we have Mr. Jonathan Whitenaur with the district attorney's office. Mr. Whitenaur, you have a negotiated plea to present?
Yes, Judge, with respect to 20 SC 174-533, the defendant would be tendering a guilty plea to count 1 aggravated assault, family violence under Alford for your court's consideration. Upon the court accepting that plea, the state would be moving to null plus count 2, that misdemeanor possession of marijuana.
Okay.
With respect to 19 SC 173-443, the defendant and the state have reached a negotiated plea, should your honor be willing to accept that today. 25 to serve on voluntary manslaughter, reduced from count 1 murder. Also entering a plea to possession of a firearm during commission of a felony and possession of a firearm by convicted felon under 133. The other counts will either be null prost, vacated, or merged.
Okay. Okay, thank you.
Mr. Satterwhite, can you hear me?
Yes.
All right. It's important that you speak up. Speak
Yes.
to that mic so the court reporter here can take down everything that we say. Agreed?
Okay.
All right, thank you, sir. If you would, please, if you'll go ahead and just raise your right hand to the best of your ability. Do you swear or affirm that the testimony you're about to give, no matter pending before this court, will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please lower your right hand. If you would please state and spell your true, correct, and legal name.
Jimmy Satterwhite, JIMMY,
And sir, how old are you today?
46.
All right. Are you now under the influence of any medicine,
No.
drugs, or alcohol?
No.
All right. And is there any medication that you normally take that you've not been given today?
No.
How far did you go in school, sir?
Finished.
Excuse me?
Finished.
High school.
12.
Finished 12th grade?
Yes.
All right. And can you read and write in the English language?
Yes.
Sir, have you had an opportunity to review the document that charges you in both cases? That is an indictment in 20 SC 174533. That's the aggravated assault, family violence, and 19 SC 173443. That's the indictment that was originally true billed by the grand jury for murder.
Yes.
All right. And do you need any more time to review either of those indictments with your attorney who's present with you today?
No.
All right. Do you fully understand the nature of the charges pending against you?
Yes.
Well, I'm going to go through a couple of your rights. I want you to listen to each one and understand that by entering a plea today, that you're waiving or giving up each of these rights. By entering a guilty plea today, you are giving up the right to a trial by jury. Do you understand?
Yes.
You're giving up the right to be presumed innocent. Do you understand?
Yes.
The right to confront any witnesses who may testify against you.
Yes.
The right to subpoena any witnesses for your defense.
Yes.
The right to testify yourself and to offer any other evidence in your defense.
Yes.
The right to have an attorney to assist you throughout the trial proceedings.
Yes.
And the right to not incriminate yourself.
Yes.
Again, do you understand that by entering a plea of guilty today on these two indictments that you are waiving or giving up all those rights that I just mentioned?
Yes.
You understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by a jury.
Yes.
All right, sir. With respect to indictment 20 SC 174533, you are entering a plea of guilty and asking the judge to accept your plea under Alford. For aggravated assault, that carries a sentence of 1 to 20 years in confinement. Do you understand?
Yes.
All right. However, is it your understanding that you'll be that the state and your attorney will be presenting a joint recommendation of a sentence of 2 years to serve to run concurrently or with the other case?
Yes.
All right. And that the state, upon the court accepting your guilty plea on that count, will move for a dismissal or null process to count 2.
Yes.
All right. With respect to indictment 19 SC 173443, for murder reduced to voluntary manslaughter, do you understand that voluntary manslaughter carries a sentence of 1 to 20 years in confinement?
Yes.
And the count possession of firearm during the commission of a felony under 106, that carries 5 years consecutive to any other sentence that's imposed.
Yes.
And with respect to possession of a firearm by convicted felon under 133, that carries a sentence of 15 years consecutive to any other sentence. Do you understand that?
Yes.
All right. Do you have any questions about those sentencing ranges with respect to both indictments?
No.
All right. Do you need any additional time to speak with your attorney now?
No.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
All right. Sir, you heard me earlier talk about the sentencing ranges and some of the joint recommendations that would be made. With regard to indictment ending 533, the state will be recommending that you be sentenced to 2 years to serve concurrent to the other case on the aggravated assault. Do you understand?
Concurrent.
Yes.
And with respect to the indictment ending 443, do you understand that the state and the defense will be making a joint recommendation to the court that you be sentenced to 25 years to serve?
Yes.
And should the court accept that plea, the state will be withdrawing its recidivist notice, which was previously filed in this case on the basis that you've been convicted of 3 or more felonies.
Yes.
Do you understand that the court is not required to follow the recommendation on either case, but can sentence you up to the maximum sentence permitted by law, which on indictment ending 533 would be 20 years and 12 months for those two counts. And with respect to indictment ending 443, with the recidivist notice on murder, you could be sentenced to a total of life in prison without the possibility of parole.
Yes.
You understand, however, that if the court does not accept this negotiation, that you would have the right to withdraw your guilty plea today.
Yes.
All right, so you need to understand that, well, this won't apply because we were not asking for any probated period. So I don't anticipate the court would be requiring any particular conditions for probation. Sir, are you entering your plea of guilty on both indictments with an understanding of everything that we just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No.
Are you satisfied with what your attorney has done for you in this case?
Yes.
Do you have any more questions for your attorney before we go on?
No.
Have you understood everything I've asked you so far?
Yes.
And understanding all of your rights, do you wish to enter a plea to these two indictments today?
Yes.
With respect to indictment 20 SC 174-533 and count 1 aggravated assault, how do you plead?
Yes.
And with respect to indictment 19 SC 173-443, with respect to count 1 murder reduced to voluntary manslaughter, how do you plead?
Yes.
And with respect to count, make sure I have the correct count. With respect to count 7, how do you plead?
Yes.
And with respect to count 9, how do you plead?
Yes.
And sir, is your decision to plead guilty made freely and voluntarily on both of these indictments?
Yes.
All right. Now, it's my understanding that with respect to indictment ending 533, that you are entering your plea of guilty pursuant to North Carolina v. Alford. Is that correct?
Yes.
And you understand that means that you may not admit guilt to every element of the crime charged, but you believe it's in your best interest to plead guilty today.
Yes.
All right. And is that what you're asking the court to do?
Yes.
All right. So are you a United States citizen?
Yes.
Sir, you need to understand a couple of time limits. If you wish to challenge this plea for legal error, you have one of two ways to do it. Your attorney can explain to you what these ways are and exactly how they work, but I have to advise you of the time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file a direct appeal. Do you understand that?
Yes.
You got to say yes or no on the record.
Yes.
All right. And the second way is a habeas corpus petition. For these indictments, each of which include felonies, you have 4 years from the date the sentence is entered to file a habeas corpus petition. Do you understand that time limit?
Yes.
All right. Your Honor, I'll go in order with the calendar. Factual basis with respect to 20 SC 174-533 is that on or about March 3rd of 2018, an officer with the Atlanta Police Department responded to 62 Pope Street Southwest, which is located in Fulton County, in reference to a dispute with a weapon. When the officer J. Worth, W-O-R-T-H, arrived, he spoke with the victim, in this case, Lakeisha Satterwhite, L-A-K-E-S-H-A, Satterwhite. She stated that she had been hit in the head with a liquor bottle by her husband, the defendant, Jimmy Satterwhite. She stated that that Mr. Satterwhite was intoxicated and, in her words, started talking crazy to her friends. An argument ensued between Miss Satterwhite and Mr. Satterwhite. During that argument, Mr. Satterwhite grabbed a medium-sized empty bottle of Hennessy and struck her about the head, leaving a visible knot just above her left eye. It was at that time that Miss Satterwhite called 911. Mr. Satterwhite apparently observed that she was doing so, grabbed the phone out of her hand and slammed it to the ground. Officers arrived on scene. Your Honor, with respect to indictment 19 SC 173-443, obviously the facts are a little bit lengthier than the other case. Those are that on September 6th of 2019 at approximately 10 p.m., this defendant, Jimmy Satterwhite Jr., shot and killed Terrell Crockett, that's T-E-R-R-E-L-L, Crockett, C-R-O-C-K-E-T-T, with a long rifle in the street in front of that same address, 62 Hope Street Southwest in Atlanta, which is located in Fulton County. After shooting Terrell Crockett, Mr. Satterwhite then turned his rifle towards Terrell's brother, Kendrick Crockett, and shot him as well. Kendrick Crockett was armed with a firearm and shot back with that pistol as he was running away. Your Honor, multiple witnesses on scene established that this shooting stemmed out of an argument and then a fight between the Satterwhites and the Crockett's, who both lived on that street, Hope Street. Witnesses indicated that at the time, Mr. Jimmy Satterwhite Jr. was intoxicated, and while the fight was occurring in the street, that he left that fight, went back to his home at 62 Hope Street, retrieved a rifle, went back onto the street, and started firing. These witnesses said that Mr. Satterwhite was the primary aggressor, and he himself later told police that he shot those brothers, the Crockett brothers, first because Terrell had punched his wife, Lakeisha Satterwhite. Your Honor, when officers arrived on scene, they did find Terrell Crockett barely alive on Hope Street. He was transported to Grady Hospital, where he died. The medical examiner and the report indicated that he died primarily from a gunshot wound to the torso. He also sustained a gunshot wound to his left arm. Officers also found on scene 11 cartridge cases of .223 caliber, which is consistent with a long rifle. That long rifle was later surrendered to the police by Mr. Satterwhite's father, who contacted police saying, "This is the murder weapon." Those cartridge casings are consistent with that style weapon. 6 9mm shell casings were also found on scene that would be consistent with witnesses indicating that Kendrick Crockett was in possession of a firearm and returned fire in response to Mr. Satterwhite firing. The detective in this case, Randall McClure, was able to speak with the surviving victim, Mr. Kendrick Crockett, at Grady. He indicated that he and his brother Terrell were visiting their uncle Darius Crockett on Pope Street, and that they heard the neighbor Jimmy yelling at Jimmy's wife in the street. This witness, Judge, the surviving witness, Kendrick Crockett, was later able to identify Mr. Satterwhite as the shooter in this incident. When Mr. Kendrick Crockett heard this argument, he went outside and observed Mr. Satterwhite arguing with his uncle, Darius. He then saw his brother, Terrell, get in between Darius and Jimmy Satterwhite, telling them to go their separate ways. Mr. Kendrick Crockett told the detective that he then heard Mr. Satterwhite say, "I'll kill you," which led to Darius and others fighting in the street there. While that fight was going on, he heard Mr. Satterwhite say, "I got something for that," and observed Mr. Satterwhite return to his house, come out, cock the gun, saw his brother, Terrell, put his hands up and say, "Hold on," at which point he observed Mr. Satterwhite shoot Terrell and then started shooting at him, Kendrick Crockett. And again, he described that that gun as a black assault rifle, and Mr. Satterwhite's father did, after this date, turn that into law enforcement. Your Honor, this defendant does have a criminal history. As mentioned earlier, the state did file a recidivist notice based on that criminal history. Relevant convictions are from 1995, a guilty plea out of Clayton County Superior Court for theft by taking felony, and some misdemeanor offenses, hit and run, false name, and fleeing law enforcement. Then in 2004, here in Fulton County, possession of a firearm by a convicted felon, and slightly more recent in 2005, possession of cocaine with intent to distribute here in Fulton County. And in 2006, 2 separate guilty pleas on 2 06 SC cases, both again for possession of cocaine with intent to distribute. Should Your Honor be inclined to accept this plea to voluntary manslaughter, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon, the state would be withdrawing that recidivist notice that was filed. We are asking that Your Honor sentence this defendant to 25 years to serve, 20 years on the voluntary manslaughter. 5 years on possession of a firearm during the conviction of felon, which would run consecutively to that voluntary manslaughter sentence. As for the possession of a firearm by convicted felon under 133, we'd ask that your honor sentence on that count as 15 years to serve consecutive to count 1 suspended. And then again, for that first case, the domestic violence case against Ms. Lakeisha Satterwhite, we are asking that on the aggravated assault, your honor, since the defendant to 2 years to serve concurrent with this voluntary manslaughter resolution. Your honor, I would note the defendant was placed into custody at Fulton County Jail on March 4th of 2018, and he's been in continuous custody since then, such that he's now served 1,539 days as of today. He's entitled to, and we'd ask that he receive credit for those days toward his sentence. And we'd ask that you follow the state's recommendation. Nothing further from the state.
Okay. Mr. Whitenauer, I see Mr. Melnick out there. And so where does this end, Ms. Jones, put Lakeisha and Carrie Evans? Jimmy Satterwhite Jr. had much bigger charges, but where does it put their cases?
Judge, if your honor is inclined to accept this plea as negotiated today, the state would be making a motion after you impose sentence with respect to those co-defendants.
Okay. Okay, Ms. Williams?
Your Honor, we do ask that you accept the joint recommendation for both cases as it relates to 19 SC 173443. I did discuss with Mr. Satterwhite at length about a viable, what we believe to be a viable defense of others defense. His major concern was that the jury, and I told him quite frankly that the jury would hear, and I didn't understand any other way that they would not find him guilty of at least the possession of a firearm by a convicted felon and during the commission of a crime. So that was his major concern, is that the jury would hear that and disregard any defense that we would put forth. But we did believe that we had a viable defense of others defense, such as Mr. Whitenauer said. Our version is a little different, that one of the brothers was actively hitting his wife in the face when the firearm exchange happened. With respect to 20 SC 174533, we are entering that under offer, and that he just believes that it's in his best interest to wrap up both cases today. And so we ask that you accept and give him credit back from the March 4th of 2018 date on both cases.
Okay.
And your honor, I would ask the court to consider hearing from the mother in this case, Shakita Crockett. She is on Zoom. It's my understanding that she would like to address the court if your honor would hear from her.
Of course. Go ahead, Ms. Crockett.
Ms. Crockett, are you able to hear us in the court? If you are, please turn on your microphone and your video. We can see that you're logged on to Zoom.
John, if she's not able, I have her statement.
Thank you. Judge, Ms. Katrina Gill is one of our victim advocates. Would your honor hear a statement through her?
Yes, go ahead, Ms. Gill.
All right, Ms. Gill, if you would, please read the statement to the court.
Wait a minute, let me get none of that. Okay. September 2019, the Crockett family lives were changed forever. The victim daughter states every day how she misses her father. We know there's nothing that will bring back my son, but we do seek justice for his death. Love, the Crockett family.
Thank you, Ms. Gill. Nothing further from the state.
Okay, Mr. Satterwhite, I have a few questions for you. Charges against you. You have just heard from ADA Whitenauer explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes.
Do you understand the court is not bound by the recommendation or the plea agreement? And I can sentence you as I deem appropriate.
Yes.
So for 20 SC 174533, although you are not admitting guilt, you have decided that it is in your best interest to plead guilty because at trial the evidence presented against you may be strong. Do you freely and voluntarily enter your plea of guilty to the charges against you?
Yes.
And for 19 SC 173443, are you pleading guilty because you are in fact guilty?
Yes.
Ms. Williams, are you satisfied that your client is competent in understanding that the plea is voluntary and there is sufficient factual basis for entering the plea?
Yes, Your Honor.
All right, I find there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and sentence you to the recommended sentence, which is as follows. On 20 SC 174533, the aggravated assault charge will be 2 years to be served concurrent to the 19 SC 173443 case, and then the possession of marijuana charge will be no prost. On the 19 SC 173443, the defendant have agreed to an overall sentence of 25 years to serve. Count 1, the murder charge has been reduced to voluntary manslaughter. That'll be 20 years to serve. I guess counts 2 through 6 are no pros. Is that correct, Mr. Whitenauer?
That counts 2, 3, and 4 vacate by operational law.
Okay, thank you.
Count 5, the aggravated assault would merge count 1. Count 6, the state offers that for null pros.
Okay.
Count 7 is a guilty plea. Count 8, the state offers that for null pros.
Okay.
Count 9 is a guilty plea.
Okay. So on count 7, the possession of a firearm during commission of a felony, that is a guilty plea, and that will be 5 years to serve consecutive, making it the 25 years total. As Mr. Whitenauer just said, count 8 is no prost. And then on count 9, the possession of a firearm by convicted, the 133 possession of a firearm, that's a guilty plea as well. That will be 15 years to serve consecutive suspended. Is there anything else?
No, Your Honor.
Yeah. Just that he get credit back from the March.
Yes,
4th date.
credit to the March 4th, 2018 date. Okay.
Your Honor, with Your Honor accepting the guilty plea on indictment 19 SC 173443, the state moves orally to null pros. The indictment with respect to Lakeisha Satterwhite and Carrie Evans under the same indictment.
Okay. And you'll send me paperwork on those to Mr. Whitenauer?
Yes, Judge.
All right. Thank you.
Thank
You're
you, Your
excused.
Your Honor, he would have been on that trial calendar, so I'm assuming you're free.
Yeah, that renders it. That one's pretty certain. Okay, and then now we want to do Ms. Clark's client now, right? All right. So which position is that again? 38?
32, I think.
32, you said?
Yes, Judge.
Yes. Okay, so bring out Harris Jr.
And Judge, I was here for Lakeisha Satterwhite, but I don't think you need anymore, right?
No, I assume you do not object to.
No, I do not. Thank you.
I figured that's why you were here. So.
Yep.
That's Stevie. That's the Satterwhite. My opinion is that they're not needs to be arraigned. 3 and 4?
Yes.
Oh, yeah. The state's moving for null process to 3 and 4. Satterwhite, Carrie Evans.
Can you? Well, here, I can print it out down there. I'm printing out the. Let's order in the courtroom, please. All right, so this is 23 SC 188860.
That's the old indictment, Your Honor. We
Okay,
object to
here's the new
non-
indictment. I'm sorry. 23 SC 190910. To Bjorn Harris Jr. is present in the courtroom with his attorney, Miss Angela Clark. And we have Mr. White now representing the state. Go ahead, Ms. Clark.
Your Honor, for the record, we object to the null cost of the original indictment number 23 SC 188860, charging Mr. Harris with voluntary manslaughter, aggravated assault, and possession of firearm during the commission of a felony. Feel that the state's changing the indictment to murder and felony murder is not being very ethical, and that he's upping the charges at this time, and we would oppose and any type of null cross of the voluntary manslaughter.
Mr. Whitenauer, do you have any response?
So I reject any allegation that this is being done unethically. I think the facts meet with the law for an indictment under murder. That's what the state presented to the grand jury, and that's what the grand jury true billed. In any event, Your Honor has already received the state's proposed order to null pros that first indictment. It was signed and filed, and here we are on the new indictment.
So as to the new indictment, Your Honor, Mr. Bjorn Harris not guilty and he waives formal arraignment. We've reviewed the indictment, so he knows the charges, the new charges that have been filed against him. And we still have our speedy trial demand.
Okay, I have your not guilty in front of me. This is your signature under here, Mr. Harris, under the not guilty.
Yes, sir.
Okay, and we're still working out whether it's going to be the first week of December 4th or the second week. More than likely, it's going to be the first, but there may be an opportunity, and we will have an answer on that later today.
Okay.
Anything else?
Will I be notified as to your decision as to?
Absolutely. Yeah, we will get you an answer today on that.
Okay, thank you.
Okay, all right, thank you. You're excused, Mr.
I love you.
Hey, enough, okay? I mean, that's not gonna work well.
I love you.
Hey.
I'm out.
Yeah.
Judge, that concludes my business before the court. May I be excused?
Yeah, I mean,
I can stand around to talk about the trial calendar, Judge.
well, let's do that right now. I just printed it out, Kathy. Can you give me a copy of it? Thank you. So we've got Harris that is set up for the number one slot. But your preference would be, I assume, to have that the second week. You made
would be.
reference to that.
It would.
And then Little and Ingram, are they ready to go?
I've been in contact with the state's ready when reached on Little. We're going to try Little first. I've been in contact with Matthew Tucker, as he does represent one of our witnesses in the case, and he is unavailable. He said that he was going to file a conflict, but I know that he has not. He stated he's unavailable next week because he's on trial in Clayton, I believe. I did show Ms. Robertson the text messages during the break, as all I have are texts. And then this week he's unavailable. Today he's unavailable for other reasons as well. And so I don't know if we're on the record. We have something to turn over to Jones on the record.
Have we been on the record? No. Well, we'll put it on the record right now. This is 23 SC 187794, DeQuasi Little and Sharice Ingram. Go ahead, Ms. Beza.
The state will be trying DeQuasi Little first, as mentioned in previous court dates. The state is currently on the record going to turn over the proffer form that we have with Ms. Sharice Ingram, who's represented by Matthew Tucker. Matthew Tucker stated he was going to file a conflict for next week because he has this trial in Clayton County. Via text message, he told me, I did show it to Ms. Robinson. However, I don't see the conflict letter filed in Odyssey. He was also going to file a conflict letter for today, as he cannot come today either. And so, yeah, so at this time, the state is turning over a copy of the proffer that we did with Ms. Sharice Ingram. The state does plan on calling Ms. Ingram, and for the record, as one of our witnesses, and her attorney is not available next week for trial. So that puts us in a interesting posture.
Ms. Jones?
Your Honor, I do recall a couple weeks ago, we had a conference basically setting this for this calendar date. This is the first I've ever heard of a proffer or a deal, so I'm a little flat-footed this morning.
So there's no deal. I want to put that on the record. I did not say deal. The proffered meeting met with Ms. Ingram, and as the agreement states, and that I handed over, we did not make a deal with Ms. Ingram. There's no offer to Ms. Ingram. The offer, as Mr. Tucker knows, and as Ms. Jones knows, for both defendants applied and pleaded to the indictment.
Ms. Jones?
Again, this is the first time I've heard about it, and generally speaking, when a client or co-defendant decides to testify, we'll see what happens after Mr. Little's trial in terms of her plea.
Yes, and that's what generally happens after the testimony, but there
Which is an agreement and a deal.
I mean, but you'd assume there was potential for Ingram to be a witness.
I've always been told that there was not going to be a deal that both could plead to life. This is the first time that I've been shown that the co-defendant has decided to make a proffer, most likely for a lesser sentence, which they're just keeping off the record till after, so they don't have to turn it over. Well, familiar with that play.
And for the record, and Mr. Tucker can definitely put on the record himself, Mr. Tucker and I and my office has not been in discussion as to what any kind of deal would be.
But Mr. Tucker's not here. And so since Mr. Tucker's representing Miss Ingram, you don't think there's any way you can go to trial next week with this? Is that your point to all this, Ms. Speza, or?
Well, I would like to try this case before the end of the year. I would just ask for the number 1 on week 2. I'm not trying to.
Well, I don't. That's the problem. I don't think there is. I mean, that's a civil week. I might be able to. There might be some juggling I can do since Mr. Whitenauer said his case is a 3-day trial, and my number 1 case on the civil is a 1-day bench trial. But there are other backups to that civil that have all been noticed, and every once in a while we have to do a civil case here. So
I don't want this case to be delayed. I mean, this case is not old, but this case should be tried, and I don't not want this case to be delayed much further.
yeah.
Whether it's first out in January, I don't know, I just leave it up to the court. All I know is from what the other defense attorney told me regarding his.
Well, I know he's had a number of
and other reasons as well.
Other reasons.
For the record, that this was signed October 5th, 2023. It is now November 27th, 2023 at 12:15, and the state finally decides to turn it over, eve of trial.
This is not eve of trial, Your Honor. And in addition, and for the record, Ms. Ingram has always alleged in this case and in the discovery to be the driver of the car that defendant Little was shooting out of. That is no secret.
I mean, given the fact that Mr. Tucker's not present, I'm going to continue it one more time, but we do need to address this case.
Ready on the 11th, Your Honor, or I know he's in trial next. He didn't give me actually. He's in trial next week.
Yeah. I know you're saying you can be ready on the 11th, but that's the civil trial week. I've sort of talked to Mr. Whitenauer about his case going then, but I've got to discuss with my staff attorney. So it's not going to go the 11th.
I guess if we can be first out for whatever January calendar you have, I would just like to be first, because there are a lot of moving pieces in this case, like most cases, but we do have quite a few.
I mean, I know, but I mean, I don't know what to tell you. It's your witness. Ingram is your witness, and her attorney's not here, right? I mean, unless you want me to keep it on the fourth calendar. All right, we'll reset it, and we'll look at Kathy. We'll look at putting that early in the year, right? All right. Just going over the calendar here on the trial calendar. Did we address Miss Jones Barber earlier today? The Marquavius Barber?
We have not. He's not on the final plea calendar, Your Honor. I think he might still be in custody. He ran into that ankle monitor funded by Fulton County that we've just, nobody told us, but now our clients are letting us know. But we stand on our not guilty plea on both cases, the family violence as well as the aggravated assault with Mr. Bridges.
I mean, but are you ready to go to trial?
I'm ready when reached.
All right. Who has this one? Bridges, you have this?
There's a couple of us that have it, depends on which case you're talking about. I think I have the aggravated assault. I think that this only has the one including the children.
Yes, Your Honor, as represented last time, is from my review of the domestic violence case, Mr. Bridges' case would actually move because his case, the facts of his case are more severe.
Okay.
Yeah, that's what I'm saying. Yeah.
Wait a minute, which one would your case would be the lead case, Bridges?
It can be, Your Honor, but there's another case. He should have a case with aggravated assault. That's Ms. McCall.
Yeah, I see that.
I would think 21 is driving the train. Position 21, at least on my calendar that was printed.
Which
That
case?
would be the one aggravated assault, cruelty to children, and possession of a firearm during the commission of a felony. Yes, ma'am.
Oh, okay. There's a whole nother one. All right. Which one is that? That's Macaulay's or Willingham's?
No, that's McCall.
And what was your announcement on that, Miss Willingham?
My announcement, Judge, is as to position 22, and the state would be ready. However, we do believe that Holly's case, or Mr. Bridges' case are more severe. The offer as to our case.
All right.
It's my understanding Mr. Bridges offered. So our case.
All right, well, we'll leave him on the calendar then.
And Your Honor, that concludes my business. I did excuse.
You're excused. Vagnerius, Cyprian, Jefferson. All right, let's grab Tucker while we can then. Mr. Tucker.
Yes, sir.
All right, so we were just discussing Little Ingram. So you've got a conflict next week?
Yes, sir. I have a special set starting December 4th, and I anticipate it to take the whole week. Hopefully not the weekend, but if necessary, we'll stay there the weekend.
And it's an older case in this?
It's 2019. It happened early 2019, like in March.
All right. Well, we reset it anyway, but I appreciate you coming on at the last minute here. So
yes, sir.
Okay.
And then I have an Xavier Thompson also.
Yes, Judge, in that case is
Which one is? I've got two calendars in front of me. So
on the final plea calendar, Judge. Let's put back to see it.
which position is that? What? 14? Okay, so you have Thompson. So where, all right. So where do we stand on Thompson?
I was, when we last visited this situation, I was under the impression it was going to be either dismissal or plea to something that would be satisfactory to my client. I think that did not flourish the way we anticipated. I know that he has he came up with medicine, so he's been trying to get persuaded to put back on his medicine. So I can talk with the prosecutor again. Hopefully we can have better results. If not, I'd say ready for trial.
Yeah, but you're not ready for trial because you got a conflict.
Oh, yes, sir. Subject to the conflict. Yes, sir.
Yeah. Yeah. Well, wait a minute. He's not on that. He's not on that trial.
Oh, okay. Okay.
All right. So still working on an offer. All right. Well, let's put him on a trial calendar then.
Okay.
Anything else?
That's it. Is the prosecutor still the same on that case? Do we know? I know somebody said that they came back to her.
Miss Willingham is, yes. She's present.
Okay. I will shoot her an email and introduce myself and try to see what we can get done.
Okay.
I appreciate it. Thank you so much, Judge.
All right. You're excused.
Have a great day.
All right. Cyprian, Jefferson. Did we address Latrice Bennett earlier? Ms. Jones?
No, she.
Is she ready for trial?
Yes, Your Honor, position 26 and 27 on, I think, the child calendar. One is a family violence, the other is not family violence when there is potential probated sentence. The other case is a prison sentence, so that will be for trial.
Okay. That's good. Is Corrine Rogers ready for trial?
Yeah, Your Honor, I discussed the offer with him today. He is rejecting that offer, so we will proceed to trial.
Okay. Who's got, let's go ahead and which position is that on today's calendar, Corrine Rogers? Who's got that with the state? Is it you, Mr. Bridges?
Which one is that, John?
29 and 30, Corrine Rogers. Oh, Willingham has it?
I'm sorry, I thought you said Kareem. Judge, my apologies.
Corrine. Mr. Rogers, why don't you come up for a minute? I'm just gonna ask what the offer was and what the maximum sentence is on it. What was the offer, Miss Jones? You remember?
It was a probated sentence, Your Honor, with the state null processing several counts across both cases. I've talked to my client in regard to that. And he stands on his not guilty today, and we'll just put it on the trial calendar, keep it on the trial calendar, and I'll continue to talk with the state if there is some resolution short of trial.
All right, Miss Willingham, can we go over the maximums real quickly? 29 and 30 on today's calendar, on the final plea calendar.
Aggravated assault with a deadly weapon has a minimum of 1 year and a maximum of 20 years. Count 2, aggravated assault, I'm sorry. I need to correct that. As to count 1, aggravated assault with a deadly weapon, family violence has a minimum of 3 years and a maximum of 20. As to count 2, a minimum of 3 years and a maximum of 20. As to count 3, possession of a firearm during the commission of felony is a mandatory 5-year consecutive sentence to all 3 counts. As to count count 5, battery family violence, a minimum of 1 day and a maximum of 12 months. As to count 6, battery family violence, a minimum of 1 day and a maximum of 12 months. As to count 7, cruelty to children in the 3rd degree, a minimum of 1 day, a maximum of 12 months.
That'd be the same for all those.
Yes.
So, okay.
And as to position 30, criminal damage to property in the 2nd degree is a minimum of
1 to 5.
Maximum 5. As to count 2, that is a minimum of 1 day, maximum of 12 months. Criminal trespass, a minimum of 1 day, maximum of 12 months. And obstructing or hindering a person making an emergency telephone call, a minimum of 1 day.
Okay, so the max on that one would be 4 years then, right?
Yes. No, 5.
What was the criminal damage to property?
The next
5.
5. Oh, okay. So it could be 8 years then. 9. All right, I'm not doing my math. And then this one is 1, 2, 3, 4, 5, 6, 7, 8. 8 plus 45, 53. Okay, I just want to make sure we're all on the same page here. Mr. Rogers, that if you go to trial and if you were to be convicted on the first case that involves the aggravated assault, you could be facing a maximum of 53 years. And then on the other case, the one that involves criminal damage to property, you could be facing a maximum of 9 years if you're convicted. I don't care. I have no opinion whether you want to take a plea or go to trial, but I did want to make sure that you're fully aware of what you could be facing if you go to trial. Okay? You understand that? I'm sure your attorneys explained this to you already, but
yeah.
And we will leave you on a trial calendar. You're excused. All right. All right. Mr. Clark?
I had 2 announcements on the trial calendar as well, Your Honor.
The trial calendar?
Yes.
Okay.
As well as the final plea. Mr. Liska is present, Your Honor.
Which position is he on the final plea calendar?
Final plea calendar, he is position
23 and 24.
All right.
We've been in communication with the state as far as the offer is concerned right now. Mr. Liska is standing on his not guilty plea. The position 24 aggravated assault charge is the one kind of driving the train. I imagine that would be the one to be tried first. Discussed it with Mr. Bridges at this time. The only thing I'm missing as far as discovery is kind of a supplemental police report, as well as some medical records, but I do believe we would still be ready to go to trial if it were to be reached. All I can say, Your Honor, otherwise is that I have leave from end of Friday. So I would ask if this is reached for some reason next week, if we could potentially start on the Tuesday. That would be my only request of the court, or if it were to be reached for the second week if time frees up. But those would be my only other requests of the court. Other than that, we would be standing on the
Okay, we will, if it is reached, we will start it on Tuesday. I'll grant that. There's a lot of people that have been sitting in jail for a while. That will,
And also, I have leave from the 7th through the 11th.
okay. All right, well, that probably makes it. What was the offer? What's the last offer?
It was on the aggravated assault, it was 15 to serve 10 confinement. On the position 23, the theft by receiving stolen property, that was a 5-year probated sentence.
And what's the max again on aggravated assault? 20?
That's correct.
And then what are the maximums on the theft by receiving, fleeing, and obstruction of a law enforcement officer?
Max on theft by receiving is 10, fleeing is 5, and then I believe the obstruction was a misdemeanor, so that would just be.
Okay, you hear all that, Mr. Liska? Just want to make sure that you're aware of what you could be facing if you go to trial and if you're convicted by a jury. Obviously, it's your right to have a jury trial. I don't have an opinion one way or another, but want to make sure you understand what you're facing. Okay, you're excused. And it looks like this is going to be reset.
In addition, Your Honor, I had position number 9, Walkins Bazile, who's also on the trial calendar.
Yeah. Yeah. Yeah, Mr. Thompson's excused. Which position was that? Yeah. Yeah, he's excused. What about Bazile now, Mr. Clark?
Yes, Your Honor, and I'm in discussion with the state to see if we can potentially resolve this. Your Honor recalls, we were here a few weeks ago on a final plea. I'd let the court know that we were waiting to provide some mitigation to Mr. Bridges. That is essentially it's records of his hospitalization in a mental health facility that I would be intending to discuss with Mr. Bridges as mitigation. We've requested that. It's been some number of months ago now. Still have not received it, which isn't unusual when we deal with community behavioral health providers, but is getting frustrating. So I've started the process of subpoenaing that information from the provider so I can get it provided to Mr. Bridges. For that reason, given the fact that he's facing a 10-year minimum on these charges, we would be asking that if this could be continued another 30 to 45 days, hopefully would allow us to receive those, for me to give those to Mr. Bridges, and then for him to consider whether there could be any change in the offer. So we would just be asking for one more reset on this.
Mr. Bridges?
Yeah, we have no objection, right? He talked to me about this.
Okay, I'll give you the reset, 45 days.
Thank you, Your Honor.
Any other announcements? Go ahead, sir.
Yes, Judge. Good morning. Well, that's a lie. Good afternoon. Craig Lewis from Ms. Bridges, Judge.
Which position is that? You know? Oh, I've got it right here.
Okay.
21.
Yes,
Okay.
sir. She has 2 positions on your calendar, Judge. She should have.
20 and 21. Okay.
In the case beginning in 23 SC, that's the one I was on. I did receive an offer this past weekend. I have not communicated it to my client as of yet. In the 21 case, I have gotten on that since we were last in court. And Mr. Bridges, no relation to my client, has turned over some discovery. I don't know what it is, but it came in this weekend, along with an offer. So Judge, now that I got it all, and I can tell you that one of the offers is 15-10 on the 21 case and 10-5, I believe, on the 2023 case. I'm gonna ask, Your Honor, given my trial calendar next week, that if the court will permit us to go into the month of January. Of course, it's your call.
Your Honor, we don't yet, because Mr. Lewis, what he failed to tell you is he just got on the second case.
Yeah.
She didn't have an attorney for the second case. That's why he's just getting discovered.
Okay.
Yeah, that's correct. I'm sorry. It's a lot, Judge.
It's a lot.
Yes, sir. 4 trial calendars next week and 3 courthouses, and I just left one in Gwinnett and headed to another one tomorrow. It's just back to back to back right now. But we clearing calendars.
That's so the 23 SC case you just got on.
No, sir. That one I was on first.
All right.
I went on that one in September, October. And I received the offer this weekend on that one. And my client doesn't know it yet. The 21 is the one I just got on.
All right, I'll give you the reset.
Thank you, Your Honor.
All right.
Sir, that concludes my business for this morning.
You're excused. You and your client are excused.
Thank you, sir. Have a great day.
All right. Any other announcements?
Yes, Your Honor. I have 2 more announcements. Position 12, Malik.
Yep.
He's in custody. Mr. Murphy has been on final plea calendar several times before. He has a pending unindicted case. Last week, Ms. Willingham sent me a global resolution on both cases, which I appreciated. I discussed it with Mr. Murphy. I think he's gonna be inclined to enter it. The one, I guess, kind of unknown right now is he's got a probation hold out of Clayton County. Long and short is I'm asking for just one more reset for me to get some information about what's going on there, so I can talk with Mr. Murphy about it, and I anticipate we'll be able to reach a resolution next time.
All right. All right, we'll reset that as well. Anything else, Mr. Clark?
Yes, positions 15 through 19, Mr. Bell.
Yeah.
We were here a few weeks ago for final plea. He's remaining, gonna remain standing on his not guilty plea. He is not noticed for trial for the 4th. So I think it would just need to be set on the next available trial.
All right. Do you hear that, Ms. Robinson? Okay, we'll put him down for trial. Any other announcements? Okay, who do you want to do? Yeah, you're excused, Ms. Marsh. What other plea? Do we have any other pleas? All right, let's do Trevisa Pierce. Come on up, Ms. Pierce. Who has that with the state? Who do you still have, Mr. Whitenauer?
Judge, I was just standing by, but on Bjorn Harris, but I can just wait an email from the court about its thoughts on 12-4 versus 12-11. That's the only case that remains on calendar for me.
I'll put it's literally going to be just me going out, and when we adjourn 10 minutes, and I'll copy you and Ms. Clark on it.
Understood, Judge.
All right.
Thank you.
Okay. Yeah, you're excused. Which position is Pierce on the final plea calendar? What position? 2-8. Okay.
Judge, I know typically I would sit up here, however, my computer is going to die. So can I go back to the table?
You can. You can. Okay, this is 22 SC 185 380 Trevisa Pierce, who's represented by Ms. Jones, and we have Ms. Willingham representing the state. Ms. Willingham, you have a negotiated plea to present?
Yes, Your Honor, and my apologies. Can Your Honor give me that case number again? I don't have it.
Sure, it's 22 SC 185380.
My apologies. Your Honor, yes, the state has a negotiated resolution on this case, or we have come to a negotiated resolution on this case. All counts, with the exception of count 5, will be null-priced, and the defendant will be entering a plea to count 5. And as part of the conditions of the and it would be probation, 12 months probation, and as part of the conditions, it would be complete family violence intervention program, have no contact with the victim, no weapons, no drugs or alcohol during the course of probation.
And we are going to be requesting first offender. I think I neglected to probably state that.
No contact with the victim. What was the other one? No drugs or alcohol.
Yes, Your Honor, and complete family violence intervention program.
And which count is count 5?
Battery family violence
Okay,
with a minimum of 1 day and a maximum of 12 months.
okay. All right, go ahead, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name, your age, and your date of birth.
Trevisa Pierce. I'm 37 years old. My birthday is November the 3rd, 1986.
You can put your hand down, ma'am. Are you now under the influence of any medicine, drugs, or alcohol?
No.
How far did you?
High school and have some college.
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Yes.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you're giving up certain rights: the right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
As discussed, the negotiation in this case is that you would enter a plea to count 5 of the indictment, to battery family violence, first offense, with a minimum of 1 day and a maximum of 12 months, and all other counts of the indictment would be non-proper. You would be required to complete family violence intervention program, have no contact with the victim, have no weapons, drugs, or alcohol during the course of your probation. Is this what was explained to you?
Yes.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
You heard me tell the court that the negotiation in this case is 12 months probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 12 months in custody?
Yes.
Do you understand, however, that if the court does not accept this negotiation, you have a right to withdraw your guilty plea today?
Yes.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you will be required to complete family violence intervention program, have no contact with the victim, have no weapons or alcohol. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes,
Are you entering your plea of guilty with an understanding of everything we just talked about?
yes,
Has anyone used any forced threats or promises which caused you to plead guilty against your will?
no,
Are you satisfied with what your lawyer has done for you in this case?
yes,
Do you have any more questions for your lawyer before we go on?
no,
Have you understood everything I've asked you so far?
yes,
Understanding all of your rights, do you wish to enter a plea to these charges to this charge today?
yes,
Is your decision to plead guilty made freely and voluntarily?
yes,
Did you in fact commit the offense to which you are pleading guilty?
yes,
Are you a United States citizen?
yes,
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
yes,
It is my understanding you are requesting from the court to be treated as a first offender. There are benefits and risks to requesting this status. The benefits are that if you do what the court orders you to do and do not violate the terms and conditions of your probation, you will not have a conviction for these offenses. The risks are that if you violate this sentence or your probation, commit a new offense, etc., we will ask you to be brought back into court and ask that you be adjudicated guilty, meaning you will have a conviction. And then the court can re-sentence you up to the maximum sentence we discussed earlier, which is 12 months in custody. Knowing all of this, do you still want to be treated as a first offender?
yes,
Have you ever been convicted of a felony before?
no,
Have you ever used first offender in any other case or any other place?
no,
Switching over to the factual basis, Your Honor. Just one moment.
All right.
Your Honor, should this case proceed to trial, the state would prove beyond a reasonable doubt that on February 11th, 2022, at approximately 8:42 a.m., a 911 call was placed reporting shots fired at 910 Newtown Circle, Southeast Atlanta, Georgia, in Fulton County. Officer Hartsfield responded and located a crime scene as well as the victim. The officer responded to the scene and spoke to the victim, who was identified as LeVar Frazier. Mr. Frazier advised that the mother of his 1-year-old son had begun arguing with him because she was intoxicated at approximately 3 a.m. in DeKalb County, where the two lived together. Mr. Frazier advised that the police were called and they made Ms. Pierce leave the location, but he instead advised he would leave because she had no place to go. Mr. Frazier advised that he then walked from 4086 Glenwood Road, Apartment 1, Decatur, Georgia, to 910 Newtown Circle Southeast, where his car was parked. Mr. Frazier decided to sleep in his vehicle due to the time of night it was. At approximately 8:30 a.m., he advised that he was awoken to the mother of his child, Trevesa Pierce, hitting him with a beer bottle. Mr. Frazier advised that she struck him once in the head, and then he was able to grab the bottle from her to keep her from further striking him. Ms. Pierce then picked up a brick and shattered the windshield. Mr. Frazier then got out and threw the brick at her windshield. During the altercation, Ms. Pierce kept asking him, where's my stuff? She then got back into her vehicle, in which his 1-year-old son, LeVar Frazier, was sitting and observing the entire altercation. Mr. Frazier advised she drove down to the end of the parking lot and turned around, and as she drove past him, she began firing a .45 caliber handgun at him, which struck the vehicle he was then sitting in. Several rounds penetrated the vehicle, with the one round that penetrated the vehicle ricocheting around the vehicle and striking him in the throat, leaving an abrasion. Officer Hartsfield asked Mr. Frazier what exactly she was asking about and what she thought he had taken, and he advised drugs. The officer was able to pull an ID photo from Omnex of Ms. Pierce based off the identifying information Mr. Frazier provided, and showed Mr. Frazier the photo. He immediately advised that it was her in the photo. Mr. Frazier signed and dated the photo, positively identifying the mother of Mr. Frazier's child as well as the person who was just shooting at him. Your Honor, I recognize that based on these facts, a misdemeanor plea seems very light. However, I have had an opportunity to speak with Mr. Frazier, who does not desire to move forward. He stated that they have moved past this, and based on that, the state was willing to provide an offer in the case. And for those reasons, we're here today.
What's the maximum sentence on the battery family violence?
12 months.
All right. Okay, Ms. Jones.
Thank you, Your Honor. Ms. Pierce is before you today in regard to this incident. We were able to provide also the state with a police report earlier in the night from 3 a.m. where this person, Mr. Frazier, ransacked in her apartment, poured bleach several places. That is actually why he was out on foot that morning. The car that was damaged was actually Ms. Pierce. We also have a protective order that we pulled from 2020 where Ms. Pierce was the victim of domestic violence and Mr. Frazier was the person, the perpetrator. In regard to that, we did provide all of that with the state in conjunction with this negotiation, Your Honor. These two have not had any further relationship. I don't think that they're going to be crossing paths again, although that case is still pending in DeKalb County. But for those reasons, we are requesting that you follow the plea agreement as outlined by the state and give Ms. Pierce a first offender status.
All right, so Ms. Pierce, you're 37 years old. You're requesting first offender, so I expect you don't have much of a record.
I don't, first time.
It's 12 months probation. The maximum is 12 months to serve. So, I mean, I don't expect you're going to screw up that badly in 12 months, but, I could turn around and if you did and sentence you to the maximum of the 12 months, although you would get credit for the amount of time that you've been on probation. Your attorney's gone over that with you?
Yes, sir.
I think what's more important is your attorney's explained to you, this is a once in a lifetime shot. There's no other first offenders out there. But like I said, at 37, you're probably pretty confident in your ability to stay out of trouble.
Yes, sir.
Okay. All right. So, Ms. Pierce, do you understand the nature of the charges against you?
Yes.
You have just heard from ADA Willingham explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes.
You understand that the court is not bound by the recommendation or the plea agreement, and I can sentence you as I deem appropriate.
Yes.
Are you pleading guilty because you are in fact guilty?
Yes.
Ms. Jones, you satisfied that your client is competent and understand the plea is voluntary and there's sufficient factual basis for entering the plea?
I do.
Okay, the court finds that you, Ms. Pierce, understand the nature of the crimes and the consequences of this plea. There's a factual basis for the plea, and the defendant has knowingly, intelligently, and voluntarily entered this plea. The defendant has requested a sentence under the First Offender Act. The court will approve that request, withhold adjudication, and does hereby notify the defendant that this plea will not be withdrawn in the event the defendant fails to fully comply with the terms of the sentence I'm about to impose, which is the recommended sentence. And that sentence is no prosecuting everything except for count 5, which is the battery family violence first offense. And that will be 12 months probation, the special conditions of completing a family violence intervention program, no contact with the victim, and no alcohol or drugs without a prescription. When can she add the family violence intervention program completed by?
It's usually I think it's 26 weeks, 24 thank you. So
6 months?
yes, and we've talked a little bit about that, Your Honor, that if she was able to complete her Family Violence Intervention Act early and while the probation is still there, that she can always contact me and then we might be able to do a motion in front of Your Honor to terminate, but we're not there yet. But she is very motivated to try to finish this and get it out of the park, so to speak. So it's behind her.
All right. Well, I'm going to add, just because I like a time certain, that program has to be completed in 6 months. So, anything else?
Not from the defense.
Okay, you're excused.
Thank you.
All right.
Oh, she's gonna have to talk to misdemeanor probation.
Oh, yeah.
Oh, there she
they
is.
are.
Read my mind. Okay.
And then we have the only other one we have is Wagner. Mr. Wagner, is he in
He
custody?
was on, and now I don't know where he went.
Oh, come on, Mr. Wagner.
I can go call them.
Why don't you call him? No, go ahead. Is there anything else out there other than this?
That's why I came to call.
All right. Okay, I see you raising your hand. Go ahead. What's up? Let's see here. Who, Sharp?
They've already reset location.
We reset it. We reset it. Sorry. Who else is in the?
What's your name, sir? In the back?
What's your name? I could. Why is he here?
But the, Latrice Bennett.
That's the trial calendar.
Yes, Judge Latrice Bennett, and I'm not really sure where we are with that one. I know Ms. Jones.
She was ready.
Oh, okay, that's the one that the subsequent one.
What position is Latrice Bennett?
There is the
43 and
last one.
44 on the final plea calendar.
43 and what?
44, yeah.
And my apologies, Your Honor, I do recall Ms. Jones mentioned that the domestic violence case is the one the defendant would be inclined to plead to. However, the complex case is a jail time offer, so she announced it.
So my memory, what did we announce on that? Ready for trial? Okay. Let me look up the.
Got another young lady right here too.
One minute. Let me look up Bennett first. Okay, ready for trial, Bennett. Yeah, I wrote down ready for trial. So Bennett's ready for trial. You're excused.
I'm sorry, which cases?
And that's
Wait a
why that was why I was making it, that's why I stated it the way I did on the record, Your Honor, because they're two separate cases. One has a domestic violence victim, and in that case, that is the case that the defendant would be inclined to plead. It is the subsequent case that would be going to trial.
Okay.
The other offer is a probation offer.
So which one involves this man?
That is going to be position 43. So it would be position 44 that Ms. Jones stated that she anticipates.
Okay, so just so you know, sir, if we go to trial, it will be the case that doesn't involve you then. Does that make sense? Okay. All right. 43 and 44. If we go to trial, it's going to be position 44. Do you have any questions? Okay. All right, you're excusing. All right, now see, who are you and what do you have?
I'm Latrice Bennett. I guess they were saying that he was supposed to be saying something about
Hold on. You're the victim. I mean, you're the defendant.
Yeah.
Yeah. Yeah. Well, yeah.
I'm sorry.
Hold off.
My bad. I'm sorry. So she needs Ms. Jones.
Yeah. We'll wait till Miss Jones comes back out. Okay, Miss Bennett?
Your Honor, I have position 25, Sarah Lee. That'll be a plea. I'm getting the paperwork completed as we speak.
Okay. Where did is Miss Jones back with a client?
I think she stepped to the restroom.
All right.
Your Honor, good afternoon.
Hey.
I came on back, so for Demarquavius Barber, I think he is position, sorry, on the trial calendar, position 21. I know that the court was inquiring about his cases themselves.
Wait, what's position?
21 on the trial calendar.
On the trial or the final plea?
Trial calendar.
He's
Trial
just-
calendar.
yeah.
You have Lizka?
No, position,
No,
Barber on the,
Barber.
number 21 on the trial calendar. He has 3 cases. On the trial calendar.
That's so strange. I have it right in front of me and it's, anyway. Mine's showing Lizka as position 21. I'm looking at the revised one. Okay.
For that one, Your Honor, I'll likely be called out on the consolidated calendar for the 4th, before Judge Emerson.
Which position?
I'm not sure. Specifically, I've talked to several of the other ADAs on that one for Judge Emerson's courtroom, and I'm pretty confident I'll be going. On my case, Devon Boozer, it was originally in before Judge Barwick and was sent over, so I'll be likely on that one. I've been prepping for that the last few days. So for Mr. Barber, I'll reach out to the victims, but we'll likely be asking for a special set date. Because I know he has 3 open.
He has 3, but you would have done the one that everybody was saying was Macaulay's.
Correct. And we were
The big one.
We're right, and we're actually trying to work that out also in our office because it seems to be a little hot potato going on. But either way, Attorney McCauley and I will likely be out in Emerson because she'll be sitting with me.
Ms. Jones, do you have any comments on this?
I don't, other than, I thought Ms. McCauley gave this back to general, just align DAs, but I can always get with her and of course, Mr. Peoples as well. See if we can resolve it for the trial.
And I was telling counsel earlier, if I'm out of pocket for next week, that's why.
Yeah, and he's explained that to me
Okay.
as well, so.
What are you saying? You're asking for me to reset?
We could just keep it on the trial docket, knowing the potential conflicts that the state has and we'll continue to work towards a resolution short of trial. Is the
Okay.
best advice I can give right now.
Same, Your Honor. I would second it. I would just ask, just keep it cleaner, just ask to reset the date itself. That way, we've just got a date certain to be prepared. That's what I would be asking, Your Honor.
Let's keep it on a trial docket, knowing that you may have a conflict.
Okay.
All right.
Understood, Your Honor. Thank you.
All right.
All right. I'll reach out to you.
No worries.
Oh, boy. All right, which one are we doing? Oh, your client is here, Ms. Jones, Bennett, Latrice Bennett.
Yes,
Well, she was going to say something and we stopped her because you weren't here. So,
I think she was just waiting on a ride. I've indicated she can go. I've got a good contact information for you. Oh, you can talk to them.
okay.
All right, Your Honor, that concludes my business.
Thank you, Your Honor.
And I just talked to her, I didn't realize, I thought she was one of the. I just got caught.
All right, Judge.
That's what I'm looking at. Alice? Who had Allison?
I'm still the attorney of record, Your Honor. Like I said, he announced last time he was in court that he was hiring, but nobody ever filed an entry. So
And I asked for it being more in line with the
Yeah, well, let's do it. You'll send me the,
Yes.
okay. You see anybody else that was floating out there on? What about, don't we have a plea, Ms. Jones, too, with Wagner, right?
Yes, he should be back on.
What about, Patrick Mills?
That was reset.
Let's go ahead and bring out Wagner, right?
Wagner?
Yeah.
He's on Zoom, Your Honor.
Oh, he's on, okay. Who's doing that? I guess Willingham, you're doing Wagner?
Yes, Your Honor.
Well. All right, Mr. Wagner, can you hear me?
Yes, sir. How you
What
doing?
position is that on the
Good morning. Good afternoon.
38? Okay. Okay. This is 22 SC 185224, Miguel Stephen Wagner, who is on Zoom. His attorney, Ms. Tanya Jones, is present in the courtroom, and Ms. Willingham is present in the courtroom representing the state. So, Mr. Wagner, before we begin, you're on Zoom, so obviously you can't lean over and ask your attorney a question. If you have any questions, comments, thoughts, or concerns about any of the proceeding that you're about ready to hear, let me know and we will arrange for you to speak with her privately, okay?
Most definitely, Your Honor. Yes,
Okay,
sir.
so do I have your permission to go forward with this while you're on Zoom?
Yes, you do.
Okay, go ahead, Ms. Willingham. You have a negotiated plea to present?
Yes, Your Honor.
Okay, go ahead. You'll have to make sure you speak into that microphone since he's on Zoom. Yeah, I have the paperwork.
Okay. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. Please state your name, your age, and your date of birth.
Miguel Stephen Wagner, 50 years old.
Are
Date
you
of
now?
birth 9/25/73.
My apologies. Can you repeat that? Because I spoke over you.
I said I'm 50 and my birthday's 9/25/73.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
12.
Can you read and write in the English language?
Yes, I can.
Have you had the opportunity to review the document that charges you in this case?
Yes, I have.
Do you fully understand the nature of the charges pending against you?
I do.
By pleading guilty today, you're giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
I do.
Your Honor, the negotiation in this case is that the defendant would be entering a guilty plea to the indictment with and he would be required to serve 2 years probation that would suspend after 1 year, considering he has completed family violence intervention program. So if that program is not completed within that 1 year, then he would not be eligible for this probation to suspend. Is this what was explained to you, Mr. Wagner?
Yes, it was.
And that's are you going forward with both counts?
Yes, Your Honor. So as to count 1, it would be 2 years probation. As to count 2, it would be 2 years probation. They are both. Count 2 is a felony offense because it's a subsequent conviction.
So count 2 would be concurrent then?
Correct.
Okay. All right.
Mr. Wagner, and also as a part of that, And Your Honor, I will get more into this as well towards the end. But as a part of that, one of the special conditions would also be no contact with the victim. I recognize the victim is logged on, and I know that that is not what she would like, but I will explain that further when we get to the end of this plea litany.
Okay.
Mr. Wagner, you're entering a guilty plea today to aggravated assault, family violence with a minimum of 3 years. And with that, Judge, the state would amend count 1 to aggravated assault and not aggravated assault, family violence. Which aggravated assault would then have a minimum of 1 year and a maximum of 20 years. Battery, family violence, subsequent conviction would have a minimum of 1 year and a maximum of 5 years. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court that the negotiation in this case is 2 years probation that would suspend after the first year if you have already completed family violence intervention program, and that you are to have no contact with the victim.
Yes.
Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law?
Yes.
Do you understand, however, that if the court does not accept this negotiation, you have a right to withdraw your guilty plea today?
I do.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to complete family violence intervention program within 1 year and to have no contact with the victim. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
I do understand.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
I am. Yes, I am.
Do you have any more questions for your lawyer before we go on?
Nope.
Have you understood everything I've asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, I do.
Is your decision to plead guilty made freely and voluntarily?
Yes, it is.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes, I am.
If you wish to challenge this plea for legal error, you have one of 2 ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You have 4 years from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, I do.
Your Honor, should this case proceed to trial, the state would prove beyond a reasonable doubt that on January 9th, 2022, at approximately 10:26, Officer A. Dorsal and Officer N. Copeland responded to a disturbance call at 1974 Bader Avenue, Atlanta, Georgia. Upon arrival, they met with Billy Sue Pelletier, who stated that she woke up and wanted her boyfriend, Miguel Wagner, to hold her. The victim stated that Mr. Wagner went to use the bathroom, then came back to the bedroom. While doing so, she decided to make the pillow inadvertently struck him in the eye, and that is when they got into a verbal dispute, and he went inside the bathroom approximately an hour later. Mr. Wagner told her that he will beat the shit out of her, took out the curtain rod, and struck her several times in the head, causing visible bodily injury to her lower body and a small lump on the front of her head. Officer Dorsal and Officer N. Copeland asked the victim if she wanted Grady to come on site. She refused. Officer Copeland placed Mr. Wagner under custody who was sitting outside in his vehicle at the time of arrival to the location. The curtain rod was logged as evidence and his cell phone was placed in the property. Mr. Wagner did not speak with law enforcement, but did admit he lost control and went too far that no matter what he told us, he still will go to jail. Your Honor, I've had an opportunity to speak with Ms. Pelletier multiple times over the course of the last two settings, because we were previously here for final plea, I believe 2 weeks ago, if memory serves me correct. When I spoke with her at that time, she was very adamant that she wanted the defendant to actually stay on an ankle monitor because she was afraid of him and that she needed to know where he was for her safety. And it is my understanding at a previous setting when I was not present, the case wasn't assigned to me at that time, but during a previous setting when this case was up for a plea at that time, that Ms. Pelletier represented the same thing at that point. However, this morning, just before when I left this courtroom and reported to another one, I received several text messages from Ms. Pelletier stating that she wanted contact, that she didn't want the defendant to be on an ankle monitor, that they're best friends, and that she wanted to be able to have contact with him. Based on my previous interactions, I do still believe that no contact is appropriate at this time. I obviously will defer to the court, but I did want it to be noted on the record that the victim in this case is now asking that there be no violent contact as opposed to no contact, but it is the state's belief that it needs to be no contact.
Okay. All right, Ms. Jones.
Thank you, Your Honor. As my client indicated, he is 50 years old. He works, does shipping and receiving. He has extensive family in Miami, Florida. He would like to go back there, which is why he wanted to put this case behind him. Your Honor, we are in agreement with the no contact order. I know that that was previously mentioned, I think when we tried to take a plea back in September. I think
I recall this. You had him in the courtroom with you then.
I
correct?
did,
And
Your
I
Honor.
recall Ms. Pelletier. I remember it all.
Yes, and I would just make also note for the record that Fulton County is no longer paying for ankle monitors, which is going to be an issue for my clients who are indigent. They're paying for the ones currently on, but they're not going to pay anymore. I don't think that this is an appropriate case for an ankle monitor. He's done really well since his release from jail on these charges. He's continuously had a ankle monitor on. And you may recall, we even had a motion to modify to try to remove it. And you indicated we'll just keep it on till the case resolves. So I don't think that that would be necessary in this case. I don't believe Mr. Wagner has had contact, doesn't want contact. And like I've indicated before, once he clears his probation, takes care of his family violence classes, my understanding is he is intending to move back to Florida.
And Your Honor, my apologies, just for the record, I wanted to make it clear that I wasn't asking for the monitor. I was walking through to explain why I was going against what the victim was asking for. I just wanted it to be clear. I'm not asking for the ankle monitor at this time.
I know we've just had a lot of discussions about the ankle monitor, so.
Oh, yeah.
Want to make sure it's on the record.
No. Okay. Mr. Wagner, do you understand the nature of the charges against you?
Yes, I do, Your Honor.
You've just heard from ADA Willingham explain all the rights you give up by any of this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, Your Honor, I do.
Do you understand that the court is not bound by the recommendation or the plea agreement, and I can sentence you as I deem appropriate?
Yes, I understand that.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Ms. Jones, are you satisfied that your client is competent, understand the plea is voluntary and there's sufficient factual basis for entering the plea?
I do, Your Honor. And I just also want to note for the record that because Mr. Wagner is on Zoom, I went over the paperwork with him and I inserted his answers as well as signed his name on his behalf with express permission.
I see that. Mr. Wagner, how do you feel about the no contact part of this?
No contact. You know, to be honest with you, we've been together for a long time, the relationship, but is it was a lot of the roller coaster, but I guess we communicate on phone won't hurt if we communicate on phone. From my understanding, when I went to court, she said she's in Chicago. I'm going to Miami, Florida, so we're gonna be far apart. When I go to Miami, Florida, it's because my mom passed away, so I don't have no parents no more. She was the last thing I had left. Is a house there waiting, and I'm gonna be in charge of the house with some cousins. But
I
she's in
remember
Chicago, I'm in Miami.
I remember your best friend was wanting to put you on an ankle monitor the last time you were
Right,
in here.
I do, sir. Yeah. Whatever you feel is fine.
Well, to be
I
clear,
know-
if I say no
yeah.
contact, that's not going to be phone. That's no contact, no phone conversations or anything.
Oh, okay.
Yeah, that's no contact.
Right.
But I mean, that's what you've agreed to, or your attorney and the state have
I'm fine with it
negotiated,
then.
and what I assume that you've agreed to.
Yes, I'm fine with that, sir.
Okay. All right. I find there's sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and recommend and sentence you to the recommended sentence as follows, which is count one to amend the aggravated assault family violence charge just to aggravated assault. That will be 2 years probation. Count two, the battery family violence charge will also be 2 years probation to be concurrent. So it'll be a total of 2 years probation. If you complete your if you complete you're required to complete a family violence intervention program. If you complete it within 1 year, we will suspend the probation after that first year. And special condition of your probation is no contact with the victim, which, as I've spelled out, means no contact. And that means Miss Pelletier cannot call you and have contact, and you cannot call her. It doesn't matter whether she agrees that it's okay to speak. That's a court order. You're to have no contact at all. Okay? Is there
Yes,
anything
sir, I
else?
understand.
Not from
No,
the
sir. Just I would like to say one thing. I appreciate it. I just gonna need, I think it's called final deposition, so I could see about taking the monitor off. Once the case is closed.
Disposition, I think you mean.
Yes,
Yeah.
and I've
yeah,
indicated that
Yeah.
once I receive it from the
Okay.
court, I will email it to him.
Yeah. Okay.
Your Honor, I just need his phone number so I can call him.
Yes.
We're talking
My
to the
phone-
probation right now.
Okay.
He is, it's 312-581-6029.
Yeah, I'm calling him this afternoon.
But it'll come off just because of the disposition.
Yeah.
Yeah.
No, well, I mean, you can put it in that it's being removed, but just because of the fact that it's, as Miss Jones has educated me, I mean, ankle monitors on probation is not a very traditional.
I can see it in some contexts.
No, I can't. I can too. I can, but it's very rare. It's very rare.
Yes.
We are done. Mr. Wagner, you are excused.
Thank you. Happy holidays. I appreciate everybody. Thank you.
All right.
God
bye-bye.
bless. Bye-bye.
Ms. Jones? Can we go back to Ms. Pierce right quick?
Yeah.
Sure.
On,
Which-
Ms. Pierce, misdemeanor probation.
Yeah.
Go ahead. Okay, I'm sorry, Your Honor. Ms. Pierce, the class is like $340 some odd for the 6 months class and the $49 probation. She just said she would have a problem with the 5 kids and paying the $349. So she was trying to see if she can get a waive, or 6 month waive, or 3 month waive, or something.
Yes, and when I was out there, she did indicate that it was going to be tough for her to pay those probation fees, and we talked about, trying to pay what you can, but given probation requesting that as well, we would just request that her probation fees be suspended while actively doing the domestic violence classes.
Okay. And given you have no issue with that, Ms. Williams? Yeah, I mean, given her lack of criminal history and the situation she is, I'll agree to waive the fees while she's attending the class.
Okay, thank
All
you.
right. All right, what else do we have?
I think the only thing left is Mr. Lee, Your Honor, out in the hall.
Which position is Lee?
Okay.
He is position 25, Your Honor.
I think Ms. Jones is going back to talk to him.
Oh, okay.
Yeah, we've been busy. So what position is this one?
RB is 13.
No,
25, I think, on the final plea.
you mean Lee, Saran Lee. Okay, yeah, Lee. Saran Lee. Okay, Mr. Lee, come on up. You have the paperwork, Mr. Clark?
It is not going to be a plea, Your Honor. Discussed it with Mr. Lee some more.
All right, so this is 22 SC 181-798, Saran Lee, present in the courtroom with his attorney, Mr. Clark. We have Ms. Willingham with the state. Go ahead, Mr. Clark.
Yes, Your Honor. The state had made a plea offer to Mr. Lee. Had been discussing it with him today. Mr. Lee would essentially what Mr. Lee's request from the court is he would like to be reset for 60 days so he can retain private counsel. At this point in time, discussing with him, I don't think he's going to be accepting the state's offer that they made him. So he would like an opportunity to be able to have this reset just so he can obtain private counsel and they can go from there. That's the request of the court. Otherwise, it seems Mr. Lee is going to be standing on his not guilty plea.
And Your Honor, for the record, I do not anticipate whoever counsel is that the state's offer is going to change. I recognize from speaking with the victim that they would prefer for the state to dismiss this case. I've made it very clear that we are not doing that. The state's offer in this case is as to count 1, aggravated assault strangulation, which has a minimum of 3 years and a maximum of 20 years. The state's offer is 5 years probation. Count 2, false imprisonment, would be null pros. That has a minimum of 1 year and a maximum of 10. Count 3, battery family violence, a minimum of 1 day and a maximum of 12 months. And that the state's offer as to that is 12 months probation to run concurrent with count 1. Count 4, hindering a person making emergency telephone call, that count would be null pros. And as to count 5, violating family violence protective order, the state's offer is 12 months probation. That count has a minimum of 1 day and a maximum of 12 months. And the state would be ready when reached.
I don't believe this is actually noticed on next week's trial calendar.
No, it's
Yeah,
not. It's
okay.
not. But the state is ready. So if he obtains counsel and I will go ahead and I will send this offer back to them. I would like to note for the record that if it's placed on a trial calendar, that this offer, regardless of who counsel is, will expire at least 10 days before the trial calendar.
Okay, did you hear all that, Mr. Lee?
Yes, sir.
So you want 60 days to explore getting private counsel?
Yes, sir.
And I'll grant that to you. But obviously, if that doesn't work out, you retain Mr. Clark as your public defender, this case will have to move forward at that point. So, but I don't see any point in going over any other details with you until you've had an opportunity to find private counsel. Okay.
Yes, sir.
Okay. I'll reset it for 60 days.
Thank you.
All right. Well, I mean, Miss Jones is talking to her client right now. Which, your excuse? Yeah. Which position is that? Tell you what, I don't know how